Please be seated. The sitting is open. The court meets today in very exceptional circumstances, for it is first hearing in the case concerning the Arbitral Award of 3 October 1899, Guyana versus Venezuela. We are all struggling to cope with the effects of the COVID-19 pandemic and trying to get on with our lives and our work in the midst of these unprecedented challenges faced by humanity due to the virus. The work of the court, like that of many other institutions, has been affected by the pandemic and the measures taken by various governments to combat it, especially the air travel restrictions. However, the court has continued to discharge its judicial functions by organizing remote meetings and deliberations and by preparing itself for the remote hearing of some of the cases that were initially scheduled to be heard in person. This is the first of those remote hearings. The court had therefore to adapt its methods of work to these challenging times to ensure the continued availability of its services to all states for the settlement of international disputes. Members of the court and the staff of the court have made strenuous efforts to make sure that hearings like the one today may take place despite the COVID-19 pandemic. In addition to adopting its methods of work and deploying the technology necessary for holding remote meetings and hearings, the court has amended its rules. On 22 June 2020, the court amended Article 59 of the rules to add a new paragraph which makes it clear that for health, security, or other compelling reasons, the court may decide to hold a hearing entirely or in part by video link. The court also amended paragraph 2 of Article 94 to provide that the reading of the court's judgment in a case may take place by video link when necessary for health, security, or other compelling reasons. In both cases, the sitting of the court will be accessible to the public by web streaming, and any interested person can follow our proceedings today either in the original language from the floor or through the interpretation to the other language. While every effort has been made to ensure the smooth conduct of this hearing, there are certain inherent difficulties with video link and remote simultaneous interpretation technology. In the event that we experience a loss of audio input from the remote participants, I might have to interrupt the hearing briefly to allow the technical team to reestablish the connection. In view of the current COVID-19 pandemic, the court has opted for a mix of physical and virtual presence during the hearing. We believe that this format works well for the court. Therefore, the following judges are present with me in the Great Hall of Justice: Vice President Shue, Judges Tomka, Abraham, Benuna, Sebutinde, Crawford, Gevorgian, and Iwasawa. While Judges Cansado Trinidad, Donahue, Gaya, Bandari, Robinson, Salam, and Judge ad hoc Charlesworth are participating remotely in the hearing. Judge ad hoc Charlesworth will make her solemn declaration by video link in a moment. All judges participating in the hearing, whether in person or remotely, are part of the composition of the court in this case. Before we start our oral proceedings today, I would like to pay solemn tribute on behalf of the court to the memory of two distinguished figures of the UN system and of international law who have recently passed away. Mr. Javier Pérez de Cuéllar, former Secretary General of the United Nations, who left us on 4 March, and Mr. Thomas Mensah, former judge ad hoc at the court, who died on 7 April. Born in Lima on 19 January 1920, Mr. Pérez de Cuéllar had recently celebrated his 100th birthday. His lifetime spanned the 20th century and the history of the United Nations. A lawyer and graduate of the law faculty of the Catholic University of Lima and a distinguished diplomat, Mr. Pérez de Cuéllar served his country and the United Nations in many capacities. Having represented his country in the Security Council in 1973 and 1974, he was appointed Special Representative of the Secretary General in Cyprus, a post he held until December 1977. In 1979, Mr. Pérez de Cuéllar was appointed as United Nations Under-Secretary General for Special Political Affairs. Elected Secretary General of the United Nations for a 5-year term beginning on 1 January 1982, Mr. Pérez de Cuéllar was re-elected in 1986 for a second term of office, which ended on 31 December 1991. Javier Pérez de Cuéllar was a tireless broker for peace. Through his diplomatic talents and perseverance, he contributed to the resolution of major crises and the settlement of some highly complex conflicts. From the ceasefire that ended the first Gulf War, to the withdrawal of Soviet troops from Afghanistan, to the conclusion of a peace agreement in El Salvador, and the implementation of the peace process in Namibia that led to its independence. As Secretary General, Mr. Pérez de Cuéllar made several visits to the seat of the court here in The Hague and always underscored the unique role of the ICJ in the peaceful settlement of international disputes. As President of the Court and on behalf of the members of the Court, the Registrar and the entire registry staff, I would like to extend our sincere condolences to the Peruvian people and government and the family and friends of Mr. Pérez de Cuéllar. I would now like to pay tribute to the memory of Mr. Thomas Mensah, former judge ad hoc of the court. Thomas Abogie Mensah, of Ghanaian nationality, was born in Kumasi, Ghana on 12 May 1932. After graduating from the University of Ghana in 1956, he continued his studies abroad, earning a first-class degree in law at the University of London in 1959, followed by a Master's of Laws degree in 1962 and a Doctor of the Science of Law degree in 1964 from Yale University in the United States. Having taught law from 1963 to 1968 in Ghana, Mr. Mensah embarked on an illustrious international legal career, which led him from the International Atomic Energy Agency to the Secretariat of the International Maritime Organization, where he served for more than 20 years as legal counsel and later as Assistant Secretary General. In 1996, when the new International Tribunal for the Law of the Sea began its functions in Hamburg, he was elected as one of its judges and then chosen by colleagues to serve as the tribunal's first president. Under his stewardship, the tribunal adopted rules and established procedures that have continued to serve it ever since. In 2012, he was chosen as judge ad hoc at our court in the case concerning territorial and maritime dispute, Nicaragua versus Colombia. Judge Mensah was a member of the Institut de Droit International, a titular member of the Comité Maritime International, a member of the Advisory Council of the British Institute of International and Comparative Law, and a member of the Standing Committee on Maritime Arbitration at the International Chamber of Commerce. Judge Thomas Mensah was not only admired for his intellectual acuity as one of the world's leading arbitrators on the settlement of international maritime disputes, and for his great sense of humanity, but was also well liked for his humor, genial spirit, and conviviality. He was one of the most prominent personalities involved in the peaceful settlement of international disputes in the past quarter of century. As president of the court and on behalf of the members of the court, the registrar, and the entire registry staff, I would like to extend our sincere condolences to the Ghanaian people and government and the family and friends of Judge Thomas Mensah. I invite you to please observe a minute of silence in memory of Mr. Javier Pérez de Cuellar and Mr. Thomas Mensah. Please be seated. I now turn to the proceedings in the case concerning the Arbitral Award of 3 October 1899, Guyana versus Venezuela. I shall recall the principal steps of the procedure in the case. On 29 March 2018, Guyana filed in the registry of the court an application instituting proceedings against Venezuela with regard to a dispute concerning, and I quote, the legal validity and binding effect of the award regarding the boundary between the colony of British Guyana and the United States of Venezuela of 3 October 1899, end of quote. In its application, Guyana seeks to found the jurisdiction of the court under Article 36, Paragraph 1 of the Statute of the Court on Article 4, Paragraph 2 of the Agreement to Resolve the Controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, to which I will refer as the Geneva Agreement. And the decision of the Secretary General of the United Nations, taken on 30 January 2018, to choose, pursuant to the above-mentioned provision, the court as the means of settlement of the controversy. On 18 June 2018, at a meeting held by the President of the Court, pursuant to Article 31 of the Rules of Court, to ascertain the views of the parties with regard to questions of procedure, the Vice President of Venezuela, Her Excellency Mrs. Delcy Rodriguez Gomez, stated that her government considered that the court manifestly lacks jurisdiction to hear the case and that Venezuela had decided not to take part in the proceedings. She also handed to the President of the Court a letter dated 18 June 2018 from the President of Venezuela, His Excellency Mr. Nicolás Maduro Moros, communicating the position of Venezuela. I will now kindly ask the Registrar of the Court, Mr. Philippe Gauthier, to read out the relevant excerpts of the letter of the President of Venezuela dated 18 June 2018. Mr. Registrar, you have the floor.
Thank you, Mr. President. I quote, "Your Excellency, very respectfully, we inform that given that Venezuela did not accept the jurisdiction of the court in relation with the controversy referred to in the so-called application presented by Guyana, and that furthermore it did not accept the unilateral presentation of the mentioned dispute, there exists no basis that could establish, even in prima facie, the court jurisdiction to consider Guyana's claims. Under these circumstances and taking into account the aforementioned considerations, the Bolivarian Republic of Venezuela will not participate in the proceedings that the Cooperative Republic of Guyana intends to initiate through a unilateral action." End of quote.
I thank the Registrar. By an order of 19 June 2018, the Court considered, pursuant to Article 79, Paragraph 2 of the Rules of Court of 14 April 1978, as amended on 1 February 2001, that in the circumstances of the case, it had to resolve, first of all, the question of its jurisdiction, and that this question should accordingly be separately determined before any proceedings on the merits. The Court thus decided that the written pleadings should first address the question of its jurisdiction, and it fixed 19 November 2018 and 18 April 2019 as the respective time limits for the filing of a memorial by Guyana and a counter-memorial by Venezuela. Guyana filed its memorial within the time limits prescribed. By a letter of 12 April 2019, the Minister of People's Power for Foreign Affairs of Venezuela confirmed the decision of his government not to participate in the written procedure and stated that Venezuela would, at an opportune moment in due course, provide the court with information in order to assist it, and I quote, in the fulfillment of its obligations as indicated in Article 53, Paragraph 2 of its statute, end of quote. On 28 November 2019, Venezuela submitted to the court a document called Memorandum of the Bolivarian Republic of Venezuela on the application filed before the International Court of Justice by the Cooperative Republic of Guyana on March 29, 2018. At this juncture, I should recall that the court does not include upon the bench a judge of the nationality of either of the parties. Guyana availed itself of the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc and chose Mrs. Hilary Charlesworth. In line with its decision not to participate in the current proceedings, Venezuela has not availed itself of the right conferred upon it by Article 31, Paragraph 3 of the statute to choose a judge ad hoc in this case. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, Paragraph 6 of the statute, that same provision applies to judges ad hoc. Notwithstanding that Mrs. Charlesworth has been a judge ad hoc and made a solemn declaration in a previous case, Article 8, Paragraph 3 of the Rules of Court provides that a judge ad hoc must make a further solemn declaration in relation to any case in which he or she is participating. Before inviting Mrs. Charlesworth, to make her solemn declaration, I shall first, in accordance with custom, say a few words about her career and qualifications. Mrs. Hilary Charlesworth, of Australian nationality, is the laureate professor at Melbourne Law School. She is also a distinguished professor and director of the Centre for International Governance and Justice at the Australian National University in Canberra. She has taught at numerous academic institutions around the world, including Harvard Law School, New York University, and Université Paris 1, Panthéon-Sorbonne. And she has lectured at the Hague Academy of International Law. In 2011, she was elected as an associate member of the Institut des Droits Internationaux. From 2011 to 2014, she sat as judge ad hoc in the case concerning whaling in the Antarctic, Australia versus Japan, New Zealand intervening at our call. Mrs. Charlesworth is the author of many publications in the field of public international law, and she serves on the editorial board of numerous international legal journals. I shall now invite Mrs. Charlesworth to make the solemn declaration prescribed by the statute, and I request all those present to rise. Mrs. Charlesworth. Mrs. Charlesworth, could you please turn on your microphone first? Ms. Charlesworth, I don't think that we can hear you. Can you try again now? No, I don't think we can hear you, Ms. Charlesworth. Can you turn on your microphone? Mrs. Charlesworth, please try again now. No, we can't hear you. I think we can all sit down and wait for a minute for Mrs. Charlesworth to try again, and maybe the technicians can help her.
Hello, is that working?
Yes, now. Please all rise.
Pardon,
Charlesworth,
Andre.
you can make your solemn declaration now.
Thank you, Mr. President. I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank you. Please be seated. I take note of the solemn declaration made by Mrs. Charlesworth and declare her duly installed as Judge ad hoc in the case concerning the Arbitral Award of 3 October 1899, Guyana versus Venezuela. After ascertaining the views of the parties, the court decided, pursuant to Article 53, paragraph 2 of its rules, that copies of the Memorial of Guyana and documents annexed thereto would be made accessible to the public on the opening of the oral proceedings. The court also decided, in light of the absence of an objection from Venezuela, that Venezuela's memorandum submitted on 28 November 2019 would be made public at the same time. In accordance with the court's practice, these documents and their annexes will be put on the court's website from today. I would now like to welcome the delegation of Guyana to this hearing. The delegation of Guyana will be participating in the hearing by video link. I note the remote attendance at the hearing of the agent, co-agent, counsel, and advocates of Guyana. In accordance with the arrangements for the organization of the proceedings which have been decided by the court, and in light of Venezuela's decision not to attend the hearing, Guyana now has 3 hours to present its oral arguments. In this sitting, Guyana may, if required, avail itself of a short extension beyond 5 p.m. in view of the time taken up by the opening part of this oral proceedings. I now give the floor to the co-agent of Guyana, His Excellency Sir Sridhar Ramphal. Sir Sridhar Ramphal, you have the floor.
Mr. President, distinguished members of the court, good day. Guyana commends, acclaims, and thanks this honorable court on this virtual hearing, which proclaims to the world a message from the court that COVID-19 notwithstanding, this fountain of global justice continues to spring forth. It is a privilege to be the first to address you as the court breaks new procedural ground. I and my colleagues who appear before you on behalf of the state of Guyana shall remain conscious of this element of novelty throughout the hearing, and we shall be ready to adapt to it as the court deems fit. No word of introduction from me can be adequate, Mr. President and eminent judges, without impressing at the very outset the singular importance of this case to the people of Guyana, whose collective patrimony is at the very center of this hearing, and who are united in defense of their sovereignty and the territorial integrity of their homeland. Guyana's official and representative delegation has been notified to the court, especially joining from the Ministry of Foreign Affairs in Georgetown are our agent, Honorable Carl Greenwich, our co-agent, Ambassador Audrey Waddle, opposition representative, Ms. Gail Teixeira, former Foreign Minister Rashid Jackson, and Ambassadors Cedric Joseph and Elizabeth Harper. Many, many other Guyanese are with us virtually today, watching these proceedings, mindful of their significance for the future of our Guyanese nation. Among them, prominently, our first people whose birthright is inviolable. I myself was born in what was the colony of British Guyana on the 3rd of October, 1928. 3 decades exactly. On that exact date, on the 3rd of October, 1899, the land boundaries of my birthplace had been affirmed, definitively settled in Paris by the award of an international tribunal of high distinction. Upon Guyana's independence in 1966, I had the honor to serve as its first Attorney General, and so to draft a constitution, the first words of which were that Guyana should be a sovereign democratic state. And that first article of the Constitution of the newly independent Guyana went on to say, the territory of Guyana shall comprise all the areas that immediately before the 26th of May 1966 were comprised in the former colony of British Guyana. As Guyana's co-agent in these proceedings, I consider myself to have a rather special responsibility. Let me try to convey succinctly, in these very words, how and why we are here today. That day in Paris, at the end of the 19th century, is now a long time away. 120 years have passed since international law spoke. During that time, colonization in British Guyana came to an end, and Guyana has now enjoyed more than 50 years of independence. That might suggest a rather ordered past, given that the boundary was definitively settled a long time ago. But that would be wrong. In a word, we are here because, contrary to international law and to the binding award of 1899, the Bolivarian Republic of Venezuela, our neighbor to the west, has cultivated a nationalist passion to disavow that day in Paris and lay claim to almost 3/4 of Guyana. It was not always so. The arbitral proceeding in Paris was, after all, instigated at the behest of Venezuela. And Venezuela enjoyed and continues to enjoy the gains brought to them by the Arbitral Award. Yet, the process that brings us here is rooted in Venezuela's repudiation of that award. Repudiation more than 6 decades after it was handed down, at a time that seemed propitious to it, the very eve of Guyana's independence in the 1960s. Paris, 1899, was the very fulfillment of Venezuela's early and quite understandable wish that the border between themselves and Britain's colony of British Guyana should not be left to negotiation with the imperial power, but should be determined by international arbitration. In this, they were supported by the United States, supported to the extent of threats from Washington of war with Britain if the matter was not settled. Britain eventually concurred. By the Treaty of Washington in 1897, brokered by the United States and concluded between Britain and Venezuela, Venezuela would have the arbitration that it demanded. That Treaty of Washington left nothing to chance. The parties agreed specifically to consider the result of the arbitration, and I quote, as a full, perfect, and final settlement of all the questions referred to the arbitrators, unquote. In short, Imperial Britain would have to abide by the conclusion of Paris. And so, of course, would Venezuela. And so it did for 6 decades, until 1962, when the government of Venezuela formally denounced the Arbitral Award of 1899 for the first time and reasserted the original pre-award claim, which amounted, as I have said, to almost 3/4 of British Guyana's, and now, of course, Guyana's sovereign territory. From the time that contention was first made, in 1962, the United Kingdom, British Guyana, and then sovereign and independent Guyana vigorously rejected it and affirmed in the strongest possible terms the validity of the award and the international boundary. Between 1962 and 1965, the parties engaged one another in a series of talks in which each tried to persuade the other of the correctness of their position, with no progress toward a resolution. But these talks did set the stage for a final round of meetings in Geneva in February 1966. On the eve of independence, Guyana participated in that conference. I did so personally as our country's Attorney General, and Guyana became a full party to the Geneva Agreement on attaining independence 3 months later, with its borders intact. As Guyana will show in these proceedings, Article 4, Paragraph 2 of that agreement clearly provided that where other means of resolution of Venezuela's contention of nullity failed, the Secretary General of the United Nations shall choose another of the means stipulated in Article 33 of the Charter of the United Nations. At the Geneva Conference, it was Venezuela that affirmed that procedure. So this is the background to the case that is now before the court. And I hope that you, Mr. President, and honorable members of the court will regard it all as somewhat helpful context for the matter you are called upon to decide at this stage of the proceedings. That matter, this hearing, is really about the court's jurisdiction, a jurisdiction specifically to consider the claims asserted in Guyana's application. Most importantly, its submission that the Arbitral Award of the 3rd of October 1899 continues to be valid and binding on the parties. Guyana's case, as you will have seen from its memorial on jurisdiction, and as you will hear from its advocates today, is based on the plain text of the 1966 Geneva Agreement, by which the parties expressly consented, one, to accept the decision of the United Nations Secretary General on the means of settlement of their dispute over the validity of the 1899 Arbitral Award, including judicial settlement by this court. And two, that the dispute shall be settled by the International Court of Justice if that be the means of settlement chosen by the Secretary General. It is unfortunate that Venezuela has chosen not to participate in these hearings. Undoubtedly, it would have been more helpful to the court for both parties to appear, to fully present their arguments in the first round and respond to each other in the second. But at least the court has not been left to speculate as to what Venezuela might have said had it appeared in this great hall of justice. By the date fixed by the court, namely the 18th of April 2019, Venezuela failed to file its counter memorial, but it promised, and I quote, information in order to assist the court, close quote. And on the 28th of November 2019, it submitted a 56-page memorandum to the court, accompanied by a 155-page annex, setting out the basis for its objections to the court's jurisdiction, and very much more besides. Guyana will respond today to all of Venezuela's contentions regarding the court's jurisdiction, as they appear in those written documents. And we will demonstrate beyond any doubt that they are entirely without foundation, and that the court unquestionably has jurisdiction to proceed to the merits phase of the case and adjudicate Guyana's claims. Mr. President, almost 60 years of Venezuela trying and failing to despoil the sanctity of the Treaty of Washington and to nullify the Paris Award. The Secretary General of the United Nations indicated to the presidents of Guyana and Venezuela in these words, and I quote, "I have fulfilled the responsibility that has fallen on me within the framework set by my predecessor, and significant progress not having been made toward arriving at a full agreement for the solution of the controversy, I have chosen the International Court of Justice as the means that is now to be used for its solution. That is why we are here, attended by the faith of the people of Guyana in this International Court of Justice and in the rule of law internationally. Mr. President, members of the court, it remains for me only to outline the scheme of presentations that will follow for Guyana. They are as follows. Professor Payam Akavan will address the court on the origin of the dispute and the circumstances leading to the conclusion of the 1966 Geneva Agreement. Mr. Paul Reichler will then follow with a careful textual analysis of the Geneva Agreement and its dispute resolution provisions, including its conferral on the Secretary General of the authority to make a final and binding decision on the means of dispute settlement that the parties are obligated to pursue, including, if he so decides, judicial settlement by the court. Professor Philippe Sands will follow him with a review of the implementation of the Geneva Agreement, including the parties' reaffirmations of it and the Secretary General's acceptance of the authority conferred upon him and the manner in which he exercised that authority. And finally, Professor Alain Pillay will address the Secretary General's ultimate decision that the dispute over the validity of the 1899 Arbitral Award shall be settled by the International Court of Justice, and the consent of the parties, including Venezuela, to judicial settlement of the dispute by the ICJ. I thank you, Mr. President, and honorable members of the court, and I ask that you now call Professor Akavan to the podium. Thank you.
I thank the co-agent of Guyana for his statement, and I now invite Professor Payam Akavan to take the floor. You have the floor.
Mr. President, distinguished members of the court, I'm honored to appear on behalf of Guyana in this proceeding on jurisdiction. I will be addressing the circumstances leading to the conclusion of the 1966 Geneva Agreement to resolve the controversy over the frontier between Venezuela and British Guyana. It is Article 4, Paragraph 2 of that agreement, in combination with the 30 January 2018 decision of the UN Secretary General, which establishes the court's jurisdiction. The history of the controversy demonstrates that the dispute between the parties was and remains about the legal validity and binding force of the 1899 Arbitral Award. Beginning in 1962, Venezuela claimed that the award was null and void, whereas the United Kingdom and Guyana have maintained that it is valid and fully binding and effective. The parties held clearly opposite views on the validity of the 1899 award, and that was the dispute dividing them. As Mr. Reichler will explain, the object and purpose of the Geneva Agreement was to obtain a final and binding resolution of that dispute. My speech will consist of three parts. First, I will provide an overview of the 1899 award that established the boundary between British Guyana and Venezuela. Second, I will address Venezuela's contention beginning in 1962 that the 1899 award is null and void. This was the basis for its repudiation of the boundary and its claim to almost 3/4 of Guyana's territory. Third, I will address the parties' exchanges between 1963 and 1965 to resolve the controversy, leading to their meeting at Geneva in February 1966, which resulted in the agreement that Mr. Reichler will address in detail. The territory of present-day Guyana comprises the Dutch settlements of Berbice, Demerara, and Essequibo, established in the early 17th century. These settlements were recognized by Spain in the 1648 Treaty of Munster, forming part of the Peace of Westphalia that ended the 30 Years' War. In 1814, the Netherlands ceded these territories to Britain. In 1831, they were consolidated into the colony of British Guyana. Upon Venezuela's independence in 1810, the boundary had not yet been determined. By 1840, however, with the discovery of gold in the upper Cuyuni River, Venezuela had proposed the conclusion of a treaty claiming the Essequibo River as its boundary with British Guyana. For its part, Britain's claim extended to the prized mouth of the Orinoco River. By 1895, the boundary dispute had escalated into a diplomatic crisis between Britain and the United States. The Monroe Doctrine strongly opposed British expansion in the Americas. By 1897, under threat of war with the United States, Britain agreed to arbitration to resolve the boundary dispute. It was, in the words of one historian, one of the most momentous episodes in the history of Anglo-American relations in general, and of Anglo-American rivalries in Latin America in particular. This was a notable instance of peaceful dispute settlement in a historical period when recourse to war was a continuation of politics by other means. The Washington Treaty between Great Britain and the United States of Venezuela was concluded on 2 February 1897. The preamble set out its object and purpose as an amicable settlement of the boundary between the colony of British Guyana and the United States of Venezuela. Article 1 provided for the creation of an arbitral tribunal, and Article 3 defined its jurisdiction to determine the boundary line between the colony of British Guyana and the United States of Venezuela. Article 8 further stipulated that the high contracting parties engage to consider the result of the proceeds of the Tribunal of Arbitration as a full, perfect, and final settlement of all the questions referred to the arbitrators. Pursuant to Article 2, the tribunal comprised 5 eminent jurists, namely 2 British judges, the Lord Chief Justice of England and a Lord Justice of Appeal of the English High Court, 2 American judges, the Chief Justice and another Justice of the Supreme Court of the United States, and as president, chosen by the 4 arbitrators, the renowned Russian jurist Fyodor de Martins. Among his contributions to international law, in 1899 alone, Professor de Martins chaired the Hague Peace Conference, which established the Permanent Court of Arbitration, introduced the so-called Martins Clause into the 1899 Hague Convention on the Laws and Customs of War, and delivered the Arbitral Award that resolved the boundary dispute between British Guyana and Venezuela. The tribunal over which Professor de Martins presided held 54 meetings. The parties presented a massive volume of documents on effectivité, covering 300 years of Spanish, Dutch, and British rule in the disputed territories. On 3 October 1899, after extensive deliberations, the tribunal established the boundary in a unanimous award. The result was widely hailed as a victory for Venezuela. The Venezuelan minister in London described it to his Minister of Foreign Affairs in these words: "Greatly indeed did justice shine forth when in the determination of the frontier we were given the exclusive dominion over the Orinoco, which was the principal aim which we sought to achieve through arbitration." The following year, in 1900, Britain and Venezuela established a joint commission to undertake the physical demarcation of the boundary. By 1905, after years of arduous work, the boundary was demarcated with pillars and geographic features stretching 825 kilometers from the Caribbean coast to the tri-junction point with Brazil in the Amazon basin. The Commission produced an official boundary map with the clear specification of the boundary line with the Arbitral Award of Paris, according with the Arbitral Award of Paris. This map appears at tab 2 of the judge's folder. The 1905 map was exceptionally accurate. It followed 15,440 points from the monument at Punta Playa in the north to the top of Mount Roraima in the south. Those points are confirmed by modern satellite imagery. In the years that followed, the 1899 award was fully respected by both parties. In 1932, a tripartite agreement confirmed the point of convergence of the boundaries of Venezuela, Brazil, and British Guyana, concluded by exchanges of notes among the three neighboring states. In 1944, Venezuela reconfirmed that the boundary was a chose jugée and that it had accepted the verdict of the arbitration for which we have so persistently asked. The boundary stood uncontested for more than 60 years. Then, in 1962, during the decolonization period, while Guyana was moving toward its independence, Venezuela suddenly repudiated the 1899 award. On 14 December 1960, the UN had adopted Resolution 1514, the Declaration on the Granting of Independence to Colonial Countries and Peoples. A year later, on 18 December 1961, the Premier of British Guyana, Dr. Chedi Jagan, petitioned the Special Political and Decolonization Committee of the General Assembly, the Fourth Committee, to bring about the immediate political independence of his country. On 15 January 1962, the United Kingdom informed the committee that it was willing to hold a constitutional conference on the independence of British Guyana. On the same day, Venezuela conveyed to the United States its intention to demand a revision of the 1899 award so that Venezuela might realize the recovery of its territory. This new policy, Venezuela noted, was based on the fact that British Guyana's independence had been introduced unexpectedly and had been immediately supported by the communist countries. Contemporaneous diplomatic dispatches confirm that Venezuelan President Betancourt was concerned about British Guyana becoming a Cuba on the South American continent. He had a plan to create a cordon sanitaire by persuading the United Kingdom to cede a major slice of British Guyana to Venezuela prior to independence. It was Venezuela's view that the possibility of achieving a revision of the boundary is better while British Guyana is still a colony. On 14 February 1962, Venezuela wrote to the UN Fourth Committee. Contrary to its unequivocal conduct during the previous 6 decades, it referred to a long-standing dispute on demarcation of the frontier. It claimed for the first time that it could not recognize the 1899 award because it was allegedly an Anglo-Russian political transaction carried out behind Venezuela's back by the Russian president of the tribunal acting in collusion with the 2 British arbitrators. The only evidence invoked by Venezuela was a document published posthumously, allegedly written in 1944 by Mr. Severo Mallet-Prévost, an American lawyer who had served as junior counsel to Venezuela 45 years earlier in 1899. It was published upon his death in the July 1949 issue of the American Journal of International Law, 13 years before it was invoked by Venezuela in 1962. The memorandum did not identify, let alone produce, any evidence in support of the Anglo-Russian conspiracy theory. Thus, on 22 February 1962, Venezuela sought to reopen its territorial claim in 1899 before the UN Fourth Committee, based on the Mallet-Prévost memorandum. Venezuela claimed for the first time that it cannot recognize the validity of the award. It called for negotiations to rectify what it portrayed as an injustice. The United Kingdom categorically rejected Venezuela's contention of nullity. A note from the Foreign Office dated 21 February 1962 made clear that there is no case to answer because the matter was settled for all time over 60 years ago by international arbitration. Another note dated 15 May 1962 reported that the Venezuelan Foreign Minister, Dr. Ignacio Iribarren Borges, had expressed his government's determination to press its territorial claim either before the United Nations committees or the International Court of Justice. On 13 November 1962, following a statement by Dr. Iribarren before the Fourth Committee, pressing Venezuela's contention of nullity, the United Kingdom representative, Mr. Colin Crowe, made a proposal for resolution of the controversy. He stated that while the British government does not accept that there is any frontier dispute to discuss, it hoped that this problem can be finally disposed of now so that British Guyana can move forward to independence without any shadow of doubt about its frontiers. In this context, the United Kingdom offered to discuss with the Venezuelan government, through diplomatic channels, arrangements for a tripartite Venezuela, British Guyana, United Kingdom examination of the voluminous documentary material relevant to this question. Such a process, Mr. Crow emphasized, would establish that there is no justification whatsoever for reopening the frontier question. He made it very clear that this was not an offer to engage in substantive talks about revision of the frontier, because it had been finally settled by the 1899 award. Venezuela accepted the British proposal. On 16 November 1962, the chairman of the Fourth Committee noted the tripartite agreement to examine the documentary material on the boundary question through diplomatic channels. He concluded that there was no need for further debate within the UN. The tripartite examination was conducted by experts appointed by the parties. The United Kingdom reiterated that its purpose was not the revision of the frontier. It was intended only to dispel any doubt by Venezuela about the validity or propriety of the Arbitral Award. Between 30 July and 11 September 1963, the Venezuelan experts conducted an exhaustive examination of British documents in London. Subsequently, in November 1963, at the request of the Venezuelan Foreign Minister, Dr. Iribarren, meetings were held with the British Foreign Secretary in London to review progress. The ministers issued a joint communiqué. They declared that the next step would be for Sir Geoffrey Mead, the expert acting on behalf of both British Guyana and the United Kingdom, to visit Caracas to examine documentary material available in the Venezuelan archives. In December 1963, Sir Geoffrey traveled to Caracas to examine materials produced by the Venezuelan government. A British memorandum dated 25 February 1964 observed that the Venezuelan authorities have been unable to supply a single shred of evidence to support their contention of nullity. The tripartite examination was concluded on 3 August 1965 with the exchange of the experts' reports. The United Kingdom and British Guyana held that there was no evidence whatsoever to justify Venezuela's contention of nullity. But Venezuela continued to insist that the award was null and void. Irrespective of this process, by 1965, Venezuela began to issue official maps depicting so-called Guyana Essequiba as the Zona en Reclamación, territory to be reclaimed from British Guyana. One such map is in tab 3 of the judge's folder. Venezuela maintains that claim to this day. The sketch map at tab 4 of the judge's folder demonstrates that Venezuela's claim constitutes more than 70% of Guyana's territory. By November 1965, it was decided at the British Guyana Constitutional Conference that the date of independence would be 26 May 1966. The need to affirm the 1899 boundary became more urgent. The Guyanese feared that with the British departure, the Venezuelan military might invade and occupy the Essequibo region. It was agreed, therefore, that British troops would remain for some time to protect the new state's territorial integrity. In this context, between 9 and 10 December 1965, the ministers of foreign affairs of the United Kingdom and Venezuela met at the Foreign Office in London in the presence of the Prime Minister of British Guyana, Mr. Forbes Burnham. The meeting was in continuation at ministerial level of governmental conversations concerning the controversy in accordance with the joint communiqué of 7 November 1963. The first agenda item was an exchange of views on the experts' report on the examination of documents and discussions of the consequences resulting therefrom. The second agenda item was to seek satisfactory solutions for the practical settlement of the controversy, which has arisen as a result of the Venezuelan contention that the 1899 award is null and void. The United Kingdom Foreign Secretary, Mr. Michael Stewart, recalled that Venezuela's contention was aimed at the validity of the 1899 award. In regard to Agenda Item 1, he inquired if the tripartite examination had satisfied Venezuela that there was no substance in their allegations concerning the award's validity. The Venezuelan Foreign Minister, Dr. Iribarren, responded that the conclusions of the British experts' report were completely unacceptable. In his view, the only satisfactory solution of the frontier problem with British Guyana lay in return of the territory which by right belonged to Venezuela. Mr. Stewart clarified that Agenda Item 2 on satisfactory solutions could only be interpreted in the narrow context of the controversy over the validity of the 1899 award. He recalled that the 13 November 1962 British offer of a tripartite examination had made clear that any consideration of the substantive question of the frontier was out of the question. Given Britain's categorical rejection of the contention of nullity, Venezuela was eager to establish an agreed procedure for resolution of the controversy. To this end, Dr. Iribarren proposed a three-stage settlement process. The first would be a mixed commission to attempt a bilateral resolution of the dispute. The next would be mediation. And finally, there would be recourse to international arbitration. On 10 December 1965, the second day of the London meeting, the Attorney General of British Guyana, Mr. Sridath Ramphal, began by emphasizing once more that the agenda ruled out the question of discussion on the substantive issue of the frontier. He stated categorically that British Guyana could not accept that the 1899 award was invalid. Mr. Burnham, too, made clear that the territorial claim could not be at issue unless the invalidity of the 1899 award had first been established. Faced with this obvious deadlock, Dr. Iribarren once again focused on an agreed procedure for dispute settlement. Venezuela had come to the conference table, he explained, not to discuss positions already established, but in full consciousness of the necessity to reach a solution of the territorial problem. He emphasized that his own proposal for a mixed commission provided for finding solutions by a series of conciliatory stages, and if necessary, by recourse to arbitration by an impartial international body. Venezuela's willingness to submit to an to an arbitration tribunal, he added, represented a great concession on her part. Mr. President, Venezuela's memorandum of 28 November 2019 observes that an award is either valid or null. There is no middle ground. The validity or nullity of an arbitral award is non-negotiable. Guyana agrees, and that was exactly the position of the parties at the December 1965 London meeting. One side insisted on the validity and binding force of the 1899 award, while the other claimed that it was null and void. Faced with this impasse, they decided on 10 December 1965 that the discussions should be continued in Geneva in the week beginning 13 February 1966. Those discussions produced an agreed procedure for resolution of the dispute under the 1966 Geneva Agreement, which Mr. Reichler will now address. Mr. President, distinguished members of the court, that concludes my presentation. I thank you for your kind attention and that you call on Mr. Reichler.
I thank Professor Akavan, and I will now give the floor to the next speaker, Mr. Reichler. You have the floor.
Mr. President, members of the court, good afternoon. It is an honor for me to appear before you and a privilege to speak on behalf of Guyana. We take this opportunity to express our deepest wishes for your health and safety, and we thank you for protecting ours by allowing us to appear before you electronically. Mr. President, it is Guyana's contention that the court has jurisdiction over its claims in this proceeding, and that your jurisdiction is derived from two sources in combination. First, the agreement to resolve the controversy over the frontier between Venezuela and British Guyana, signed at Geneva on 17 February 1966, and second, the decision of the Secretary General of the United Nations, pursuant to Article 4.2 of that agreement, that the controversy shall be resolved by the International Court of Justice. I will address the first of these sources of your jurisdiction, the 1966 Geneva Agreement. Professor Pele will address the second source, the decision of the Secretary General. In between, Professor Sands will cover the period between 1966 and 2018 and the way the Geneva Agreement was faithfully implemented by the parties and by the Secretary General during that 52-year period in strict accordance with its terms. My presentation on the 1966 agreement is in three parts. First, I will review the terms of the agreement in order to establish their ordinary meaning in their context and in light of the treaty's object and purpose, consistent with the customary law principles codified in Article 31 of the Vienna Convention on the Law of Treaties. Second, after perhaps a coffee break, if the President deems that that is the appropriate time, I will call your attention to the negotiation and ratification of the treaty, including especially the contemporaneous statements of the parties as to its meaning. And third, I will compare Guyana's reading of the text with Venezuela's current reading of it, as set out in its memorandum of 28 November 2019, and demonstrate that Venezuela's current interpretation is erroneous, illogical, and completely contrary to the way Venezuela itself understood the same text in 1966 and for decades thereafter. I begin with the text of the 1966 agreement, which is at tab 5 of your judges' folders. The object and purpose of the agreement is reflected in its title. This tells us that it is an agreement to resolve the controversy between Venezuela and the United Kingdom of Great Britain and Northern Ireland over the frontier between Venezuela and British Guyana. The object and purpose of the agreement is further reflected in the preamble, paragraph 5, which declares that the parties have, quote, reached the following agreement to resolve the present controversy, close quote, which it, like the title, describes as, quote, the controversy between Venezuela and the United Kingdom over the frontier with British Guyana. Article 1 further defines the controversy between Venezuela and the United Kingdom that the agreement purports to resolve as the controversy, quote, which has arisen as a result of the Venezuelan contention that the Arbitral Award of 1899 about the frontier between British Guyana and Venezuela is null and void. This text unambiguously establishes that the object and purpose of the 1966 agreement was to resolve the controversy that arose as a result of Venezuela's contention that the Arbitral Award of 1899 about the frontier between British Guyana and Venezuela is null and void. As Professor Akhavan has explained, Venezuela's contention was formally made for the first time in 1962, more than 60 years after the Arbitral Award was issued. This novel Venezuelan contention was immediately and emphatically rejected by Britain and British Guyana. However, in 1963, amidst concern about a possible armed conflict with Venezuela upon British Guyana's forthcoming independence, the UK agreed to engage with Venezuela in a mutual examination of archival documents pertaining to the validity of the 1899 award. This process continued through the end of 1965, with each side holding fast to its initial position. This is the controversy they took with them to Geneva in February 1966, as Professor Akhavan has recounted, and which they agreed at Geneva to resolve. None of these facts about the antecedents to the Geneva Agreement are disputed by Venezuela in its written submissions in this case. Beginning with its first article, Article 1, the Geneva Agreement sets out the procedures agreed by the parties to resolve the controversy over the validity of the Arbitral Award. The first three articles, Articles 1, 2, and 3, establish a mechanism by which the parties agreed, in the first instance, to attempt to resolve the controversy diplomatically through a mixed commission. By its text, Article 1 mandated the mixed commission to seek, quote, satisfactory solutions for the practical settlement of the controversy between Venezuela and the United Kingdom. Article 2 then provided that the mixed commission would consist of 2 representatives of each party to be appointed within 2 months of the agreement's entry into force. And Article 3 required the commission to issue interim reports every 6 months. But the Geneva Agreement does not end there after Article 3. Although the parties agreed to seek a practical settlement in the first instance, they did not presume that they would be successful, especially after 3 years of failed negotiations leading up to Geneva that had seen no narrowing of their differences whatsoever. To the contrary, they agreed at Geneva on another procedure to assure a definitive resolution of the controversy in the event that the Mixed Commission failed to do so. And this procedure was set out in Article 4. Article 4 is divided into two parts. It begins with Article 4.1. This provides that if the Mixed Commission has not arrived at a full agreement for the solution of the controversy within 4 years, it shall refer any outstanding questions to the governments of Guyana and Venezuela, and that the two governments shall, without delay, choose one of the peaceful means of settlement provided in Article 33 of the Charter of the United Nations. Two key facts in regard to Article 4.1 are undisputed by the parties in these proceedings. First, the Mixed Commission did not arrive at an agreement for the solution of the controversy. And second, the two governments did not reach an agreement on a means of peaceful settlement under Article 33 of the Charter. Venezuela has helpfully confirmed these facts in its memorandum of 28 November 2019, which is at tab 6 of your folders. At paragraph 24, Venezuela acknowledged that the Mixed Commission created in accordance with Article 1 of the agreement exhausted the 4-year period granted to seek a satisfactory settlement of the dispute pursuant to Article 4.1 without achieving its objective. And at paragraph 32, Venezuela wrote that Venezuela and Guyana failed to agree on the choice of a means of settlement. But neither of these failures was able to prevent the resolution of the controversy because in Article 4.2, the parties foresaw that this very situation might arise and established a fail-safe procedure for resolving the controversy in the event of an impasse under Article 4.1. According to Article 4.2 of the 1966 agreement, which is again at tab 5, if the parties are unable to reach agreement on a means of settlement under Article 33 of the Charter, they are required to refer the decision as to the means of settlement either to an appropriate international organ upon which they both agree, or, failing agreement on this point, to the Secretary General of the United Nations. In regard to this aspect of Article 4.2, the parties agree on 3 more key facts. First, that they failed to reach agreement on an appropriate international organ to choose the means of settlement. Second, in compliance with Article 4.2, they did jointly refer the decision as to the means of settlement to the Secretary General. And third, that the Secretary General formally accepted the parties' conveyance of authority to him to decide on the means of settlement under Article 33 of the Charter, and he agreed to exercise the responsibilities confirmed upon him. The parties' agreements on these 3 facts are confirmed in Venezuela's memorandum of 28 November 2019 at paragraph 32, which acknowledges their failure to agree on an appropriate international organ, and in the annex to that memorandum, which is at tab 7 of the folders, at pages 35 and 36. As shown on your screens now, Venezuela here confirms that because of the parties' failure to reach agreement on an appropriate international organ, quote, there is an unequivocal interpretation that the selection of the means of settlement will be made only by the Secretary General of the United Nations. And further, in a letter dated April 4th, 1966, the Secretary General of the United Nations, U Tant, accepted the functions attributed to him by Article 4.2 of the Geneva Agreement considering that those functions are of such nature that they can be properly performed by the Secretary General of the United Nations. In addition to providing that failing an agreement on an appropriate international organ, the Secretary General would decide on the means of settlement of the parties' controversy. Article 4.2 further provided that if the means so chosen do not lead to the solution of the controversy, the Secretary General of the United Nations shall choose another of the means stipulated in Article 33 of the Charter of the United Nations, and so on until the controversy has been resolved, or until all of the means of peaceful settlement there contemplated have been exhausted. And in relation to this provision, there are 4 more pertinent facts that are agreed by the parties. These will be addressed in greater detail by Professor Sands and Professor Pele. For present purposes, it will suffice simply to identify those facts. First, the Secretary General decided that the first means of peaceful settlement would be his good offices. Second, that choice and the Secretary General's authority to make it under Article 4.2 were not contested by either party. Indeed, they were positively accepted by Venezuela. Third, the good offices process took place and continued for 27 years under 4 successive Secretary Generals, but it failed to resolve the controversy. Fourth, after determining that the good offices process had failed to resolve the controversy, Secretary General Antonio Guterres expressly invoked his authority under Article 4.2 and decided that the next means of peaceful settlement of the controversy under Article 33 of the Charter shall be judicial settlement by the ICJ. These 4 facts are all acknowledged by Venezuela in its memorandum at paragraphs 33, 34 through 37, 48 through 50, 54, 67, and 69. With all of these facts undisputed, the question now before the court is this. Under the terms of the 1966 agreement, is a decision by the Secretary General choosing the court as the means of peaceful settlement of the controversy binding upon the parties, or are the parties required first to express their agreement with the Secretary General's decision before it becomes binding on them? A review of the Geneva Agreement's terms in their context and in light of the agreement's object and purpose makes clear that the answer to this question can only be that the Secretary General's decision on the means of settlement is binding upon the parties without the need for their further agreement. Article 4.2 states expressly that if the parties are unable to agree on the means of settlement or on an appropriate international organ to choose the means of settlement, quote, they shall refer the decision on the means of settlement to the Secretary General of the United Nations. This makes clear that the Secretary General was conferred with the power to make a decision on the means of settlement. What is also notable is what Article 4.2 does not say. It does not say that the decision of the Secretary General is subject to the subsequent agreement of the parties, or that such agreement is required for his decision to be final or binding upon them. The absence of any language subjecting the Secretary General's decision to the parties' agreement is conclusive in its own right, but it takes on added significance when it is compared to the text regarding other prior stages of the settlement process laid out in Article 4. For example, as underscored on this slide, Article 4.1 requires that upon the mixed commission's failure to resolve the controversy, the parties shall together, that is by agreement, choose the means of settlement under Article 33. Article 4.2 then provides that if the parties should not have reached agreement on the means of settlement, they must refer the decision as to the means of settlement to an appropriate international organ upon which they both agree. Failing that agreement, they must refer the decision to the Secretary General. In this manner, the parties to the 1966 agreement provided that whenever the agreement of the parties is required to advance to the next stage in the dispute settlement process, the agreement says so expressly. In this context, the only logical explanation for the absence of any requirement that the parties agree to the Secretary General's decision on the means of settlement is that this was deliberate. The parties' agreement was not required because the Secretary General's decision was intended to be final and binding and not subject to their subsequent approval. In fact, by agreement of the parties, the Secretary General was entrusted not only with the power to decide on the means of settlement, but with the duty to make a choice in order to resolve the controversy. Article 4.2 specifies that the Secretary General, quote, shall choose. The language is mandatory. It creates mandatory responsibilities for the Secretary General, as Secretary General Outant recognized in his letter to the parties of 4 April 1966. In that letter, which is at tab 8 of your folders, in both English and Spanish, he formally accepted those responsibilities, which he considered to be of a nature which may appropriately be discharged by the Secretary General of the United Nations. Secretary General's letter thus constitutes an express acceptance of obligations in writing within the meaning of Article 35 of the 1969 Vienna Convention and general international law. That power and that duty, duly accepted by the Secretary General, and which are therefore part of United Nations law, are limited only by the requirement that the Secretary General choose one of the means of settlement enumerated by Article 33. Even more to the point, the context and the object and purpose of the agreement also make it perfectly clear that the Secretary General's decision was intended to be binding upon the parties without need for their subsequent approval. Article 4.2 was included in the agreement precisely to ensure that there would be a final and complete resolution to the controversy if the parties themselves failed to agree on the means of settlement. The responsibilities of the Secretary General under Article 4.2 are engaged when there is no agreement between the parties. To suggest, as Venezuela now does, that the binding character of his decision on the means of settlement is conditioned on the parties' agreement with that decision, when they actually agreed to empower him to break their deadlock and avoid a permanent impasse, stands the Geneva Agreement on its head. It defeats its very object and purpose. Article 4.2 ends with the words, quote, until the controversy has been resolved. The terms of the agreement make it plain that the parties did not intend for the controversy to remain unresolved. Their object and purpose was precisely to avoid a permanent impasse. This is reflected in the title of the agreement, to resolve the controversy, and the preambular language that the parties have reached the following agreement to resolve the present controversy. If, to the contrary, the parties had left themselves free to disregard the decision of the Secretary General on the means of settlement, there would have been no assurance that the controversy would ever be resolved. Either party, by simply refusing to accept the Secretary General's decision, could have single-handedly prevented the resolution of the controversy and thwarted the object and purpose of the 1966 agreement. And this is confirmed by the negotiations that resulted in the 1966 agreement and the contemporaneous statements of the parties as to its meaning, to which I will now turn. To be sure, it is not necessary in these proceedings to invoke the travaux préparatoires or the conduct of the parties, given the plain meaning of the terms of the agreement, but it may still be worthwhile to examine them, if only to confirm that the terms of the agreement mean exactly what they say. That is, that the parties empowered the Secretary General to decide on the means of settlement of their controversy, that his decision would be binding on them, and that he was to continue to exercise his power to choose the means of settlement until a final resolution of the controversy was achieved. Mr. President, this might be an appropriate place, if you deem it convenient, to take the afternoon coffee break. If not, I'm pleased to continue.
Please continue. We will observe the coffee break at the end of the second part of your presentation.
Thank you, Mr. President. I shall. Now, this is reflected first in the joint statement issued by the parties on 17 February 1966, immediately upon conclusion of the Geneva Agreement. This document is at tab 9 of your folders. It begins, as a consequence of the deliberations, an agreement was reached whose stipulations will enable a definitive solution of these problems. And it concludes that the agreement provides the means to resolve the dispute which was harming relations between two neighbors. The purpose of Article 4.2 and the negotiations leading to its adoptions were described contemporaneously by the foreign minister of Venezuela, who led Venezuela's delegation in Geneva, in his address to the Venezuelan National Congress, calling for ratification of the agreement on 17 March 1966. The address is at tab 10 of your folders. As you can see there, Foreign Minister Iribarren underscored that Venezuela's objective at Geneva was to obtain an agreement that would assure a complete, final, and binding resolution of the controversy. He had little faith that this would be accomplished by further negotiations, given the firmly entrenched positions of the parties on the validity of the 1899 Arbitral Award. This is why, he explained, when the UK proposed that the Mixed Commission be given 10 years to reach an agreement resolving the controversy, Venezuela responded that the Commission should have a very limited life of only 3 months before advancing to the next stage of the dispute settlement process. The parties ultimately agreed on a 4-year mandate for the Commission as a compromise. The Venezuelan foreign minister explained to the National Congress that his main goal in the negotiations was to make sure that if, as expected, the Mixed Commission failed to resolve the controversy diplomatically, it would not remain unresolved indefinitely, but would be submitted to binding international dispute settlement so that a definitive solution would ultimately be achieved. In the speech he gave urging ratification of the agreement, he described precisely how this goal was to be achieved. Finally, in an attempt to seek a respectable solution to the problem, I put forward a third Venezuelan proposal that would lead to the solution for the borderline issue in 3 successive stages, each with their respective time frame, with the requirement that there had to be an end to the process. A mixed commission, B, mediation, C, international arbitration. This third Venezuelan proposal was rejected by the British at the London meeting in December 1965. But according to the foreign minister, he made the same proposal in a slightly different language at Geneva, which the UK and British Guyana ultimately came to accept. He explained the final stage of negotiations and the resulting agreement in the following terms. In conclusion, due to Venezuelan objections accepted by Great Britain, there exists an unequivocal interpretation that the only person participating in the selection of the means of solution will be the Secretary General of the United Nations and not the Assembly. Last, and in compliance with Article 4, if no satisfactory solution for Venezuela is reached, the award of 1899 should be revised through arbitration or a judicial recourse. The foreign minister left no doubt about what Venezuela intended, and the parties understood by his insistence that judicial recourse be authorized under the 1966 agreement. After some informal discussions, our delegation chose to leave a proposal on the table similar to the third formula, which had been rejected in London, adding to it recourse to the International Court of Justice. The delegations of Great Britain and British Guyana, after studying in detail the proposal, objected to the specific mention of recourse to arbitration and to the ICJ. The objection was bypassed by replacing that specific intention by referring to Article 33 of the United Nations Charter, which includes those two procedures, that is, arbitration and recourse to the International Court of Justice. And the possibility of achieving an agreement was again on the table. It was on the basis of this Venezuelan proposal that the Geneva Agreement was reached. Thus, it was Venezuela which proposed that Article 4 be drafted so as to assure a definitive resolution of the controversy, ultimately, if so decided by the Secretary General, by arbitration or recourse to the International Court of Justice. There is thus no doubt, Mr. President, from either the terms of the agreement, the negotiating history, or the contemporaneous statements by the parties immediately following its conclusion, that Article 4.2 was intended to assure that there would be a final resolution of the border controversy, that the Secretary General was empowered to decide on the means of settlement to be employed, choosing from among those listed in Article 33 of the Charter, and that the parties understood and intended that if the Secretary General so decided, the controversy would be settled by the ICJ. This was Venezuela's understanding of the Geneva Agreement and of Article 4.2 in particular at the time it signed and ratified the agreement in 1966, that the Secretary General was empowered to decide on the means of settlement, including recourse to the ICJ, and his decision would be final and binding on the parties, ensuring that there would be a definitive resolution of the controversy over the validity of the 1899 Arbitral Award. Indeed, as the foreign minister of Venezuela himself emphasized, quote, it was on the basis of this Venezuelan proposal that the Geneva Agreement was reached. That was how Venezuela understood the agreement in 1966. Venezuela's current reading of the agreement, to which I will now turn, is completely at odds with the interpretation given by its foreign minister, who negotiated and agreed to its terms and explained their meaning to the National Congress upon ratification. This current reading is set out in 3 documents that Venezuela has submitted to the court.
Mr. Reichler, I think that we can stop here. It is an appropriate moment for the court to observe a coffee break of 10 minutes.
Thank you very much, Mr. President. I wish you a good coffee, and I hope that it's real and not virtual.
It will be a real one. And I will ask all those who have joined us virtually, maybe to have their coffee, but not to go away. We'll be back in 10 minutes.
Thank you, Mr. President.
Adjourned.